Good morning. This is Rajeshkumar. Today we are going to discuss about the six doctrines of contract law. The video content has been made available for informational and educational purpose only. Let's start with the first doctrine, parole evidence rule. The parole evidence rules state that if a written contract is intended to be a full and final expression of the parties' agreement, then evidence of prior or contemporaneous statements that contradict or vary the written terms cannot be admitted. This rule aims to uphold the integrity of written agreements, emphasizing the importance of the document as the primary source of a term. In other words, the parole evidence rule prevents the introduction of external evidence, or oral or written, that contradicts, modifies, or supplements a written agreement, assuming that the written contract is intended to be a complete and final version. A rule is rooted in the principle that parties who commit their contract to writing intend for that document to capture all agreed upon terms. Let's discuss the relevant case laws related to the parole evidence rule doctrine. Jacobs versus Batavia and General Plantation Trust Limited in 1924. This case emphasized that if a contract is a complete written agreement, then no external evidence can be introduced to alter its terms. In other words, this case established that parole evidence is inadmissible to add, vary, or contradict a written agreement. However, exceptions exist, such as for ambiguity or fraud. In Allen versus Pink case in 1838, this case demonstrated that parole evidence can be admitted when a document is not intended to encompass the full terms of the agreement. In other words, parole evidence was allowed because the written contract was found not to be complete, highlighting an exception to the rule when the written agreement is considered partial or not final. A Law Commission report 1986 number 154 recommends modernizing this parole evidence rule to make it less rigid, acknowledging the practicalities of contract dispute where the external evidence can sometimes provide essential context. The report critiques the parole evidence rule, recommending that it should be interpreted with flexibility to allow the relevant non contradictory evidence for clarity or to establish the terms, especially in commercial context. Hence, the parole evidence rule protects the integrity of written contracts, but is often criticized for being too rigid and sometimes unfair, particularly when it prevents parties from introducing evidence that could clarify ambiguous terms or correct a misunderstanding. The exception to the rule is fraud, mistake, incomplete contracts, make it somewhat flexible, but these are applied inconsistently. An innominate term. Let's move on to the next principle, innominate term. An innominate term is a term in a contract that cannot be classified strictly as either a condition, means a fundamental term to allow for termination if breached, or a warranty, a minor term. Instead, the consequences of breaching an innominate term depend on the severity of the breach and its effect on the contract. An innominate term is a contractual term, not clearly classified as a condition or a warranty. The remedy for breach depends on the severity of breach impact on the contract purpose. Let's discuss a couple of cases. Hong Kong Fur Shipping Co. Limited versus the Kawasaki Kisen Kaisha Limited in 1962. This case introduced the concept of innominate terms, indicating that the court should evaluate whether a breach deprives the injured party of the contractual substantial benefits. This case, the court held that whether a breach of an innominate term allows for termination depends on whether it deprives the innocent party of substantially the whole benefit of the contract. So the next case is the Hansa versus Unknown case in 1976. It's reinforcing the approach in Hong Kong Fair case. This case involved a contract for the sale of goods and demonstrated that not all breaches of innominate terms justify termination. The another case of Chivia Envy versus Bremer case, the court focused on the breach effects rather than labeling the term as a condition or warranty. So it's granting a remedy based on the actual harm caused by the breach. The concept of innominate term introduces flexibility into contract law by focusing on the consequences of a breach rather than the label attached to the term. However, this flexibility can also lead to uncertainty as parties may not know in advance whether a breach will justify termination. So the court must engage in a detailed fact specific analysis to determine the impact of the breach. Let's move on to the third term, the anticipatory breach of the contract. An anticipatory breach occurs when one party, before the time of performance, clearly indicates that they will not perform their contractual obligation. This allows the innocent party to either terminate the contract immediately or wait until the time of performance to see if the breach actually occurs. In other words, it occurs when one party communicates before the performance is due an intention not to fulfill the contractual obligation. The other party may then accept the breach and sue immediately or wait until the performance is due. Let's discuss the couple of cases related to the anticipated breach of contract. Foster versus Dela 2 in 1843, the claimant was permitted to sue immediately after the defendant communicated an intent to breach before the contractor's performance date. This seminal case established that innocent parties is entitled to sue for breach of contract immediately after the anticipated breach without waiting for the time for the performance. Whereas in White and Carter Council, Zulmita versus McGregor in 1962, this case, the innocent party elected to affirm the contract and perform it despite the other party's refusal. So, and the House of Lords held that they are entitled to the contract price. This case highlights that innocent party could elect to perform the contract and claim the full contract price, even if other party repudiates. The third case lies the Hounslow LBC versus Stickingham Garden Limited in 1970. It was emphasized that a party cannot force a reputation to complete a contract when the other party has not accepted the breach. Hence, the anticipated breach is beneficial because it allows the party to take early action to mitigate losses rather than waiting for the actual breach to occur. However, if the innocent party chooses to affirm the contract and insist on performance, they must be careful as the court may not allow recovery of unnecessary losses that could have been avoided by terminating the contract. Contract for necessaries by a minor. Under the Sales of Goods Act 1979, Section 3, a contract for necessaries, essential term items with a minor is enforceable. Necessaries are goods suitable for the minor conditions in life and actual requirements. For example, in Nash versus Inman case in 1908, this case confirmed that only the necessary items, not luxury goods, are enforceable in a contract with a minor. And similarly, in the Profound Sports Management Limited versus Proactive Sports Management Limited in 2006, a contract with a minor for representation in professional sports was voided, reinforcing that the contract with minors are only enforceable if strictly for necessaries. Sales of Goods Act 1979, Section 6. Section 6 covers the situation where the subject matter of a contract ceases to exist at the time of contracting. If goods perish before the sales without the seller's knowledge, the contract is void. The case is the Courtier versus Hast in 1856. Here, the contract for corn that perished was found void as the goods did not exist when the contract was made. In McRae versus the Commonwealth Disposal Commission in 1951, the court held that when one party assures the existence of the goods that do not exist, it may constitute a breach rather than applying the section 6, shifting the liability to the promisor. The application of Section 6 generally aligns with the res extincta doctrine, providing a pragmatic approach when both the parties are unaware that goods have perished. The rule reflects a balance between fairness and risk allocation. However, the cases like Makara exposes limitations, as the buyer often have limited recourse under the Section 6 if they suffer financial loss from the seller misrepresentation. Additionally, the Section 6 does not cover cases where goods are only partially damaged, leading to potential ambiguity. Courts often distinguish between perished and damaged, applying the Section 6 in cases where goods are wholly unfit for sale. This limitation is sensible but underscores the narrow scope of the section. Moreover, the provisions does not apply if the goods are perishable by nature, such as fresh produce, which may lead to disputes over its applicability based on the nature of the goods in question. Remedy of rectification. Rectification is a remedy used to correct mistakes in a written contract so that it accurately reflects the party's intention. The courts apply rectification when both the parties have a clear common intention that the written agreement fails to capture. The relevant case was our Chartbook Limited versus Persman Homes Limited in 2009. The court rectified a contract to reflect the parties shared the intention where the written agreement did not match the intended meaning. In Nizam case in 1970, it was established that rectification requires clear evidence of mutual understanding that was inaccurately recorded in the contract. So these cases and doctrine illustrate the nuances in the contract law and provide remedies aligned with fair contractual performance and intent. Each concept emphasizes how the court balances the legal formalism with the practical fairness. The remedy of rectification serves as a key role in ensuring the contracts align with genuine intentions, prioritizing the substances over the formality. It safeguards the parties against unjust consequences from clerical or drafting errors, maintaining the fairness in contractual relationship. However, the courts have such high standard for rectification, often requiring the convincing proof of mutual intent. While necessary to prevent abuse, this evidentiary burden can exclude genuine cases where proof may be challenged to provide, such as oral agreements not recorded in writing. To conclude, each of these doctrines plays a crucial role in contract law, with the relevant case laws providing guidance on their applications. The parole evidence rule, innominate terms, anticipatory breach, and rectifications all involve balancing the need for certainty in the contract with fairness and flexibility in addressing the unforeseen circumstances. However, the rigid application of these rules can sometimes lead to harsh results, and courts frequently engage in balancing the acts to ensure justice is served in each case. Thank you.